The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to this webinar. My name is Alice Turley, and I will be your host this afternoon, discussing how to conduct effective data protection impact assessments, or DPIAs, to minimise privacy risks and maintain GDPR compliance. I am a data protection and compliance consultant and trainer with IT Governance Europe. My background is in compliance, data protection and consumer protection in the insurance, advertising and education industries across the last 19 plus years. IT Governance itself is a company that's grown very substantially to become a global one-stop shop for everything to do with information security, data protection and GDPR. This means we provide services not just to do with IT service management and project management, but much more substantially with business continuity incident management, penetration testing, PCI, cyber resilience, ISO 27001, and of course the General Data Protection Regulation. We are a single entity that you can go to get everything that you might need in order to get yourself GDPR compliant, with a package of products and services that are appropriate for your organisation. Firstly today, we're going to have a brief look at the effect of the EU General Data Protection Regulation, or GDPR, on data protection impact assessments, DPIAs, and the benefits to a business of conducting a DPIA. We will secondly take a look at the legal requirements of a DPIA as detailed under Section 3 of GDPR, and when a DPIA is considered mandatory. We will then consider high-risk DPIAs and how they should fit within your risk management framework. And finally, we will take a look at the practical steps you can take to conduct an effective DPIA. I should note at this stage that by the end of this webinar, you will have had an introduction on how to conduct an effective DPIA, but obviously you will not be an expert in doing so until you've gone through a few yourselves. I will be talking today for about 35-40 minutes, and while you will have an opportunity at the end of the webinar to ask questions, if you have any questions you would like to ask during the webinar itself, please use the questions function in the GoToWebinar panel on your screen. You'll see a box marked questions. If you open that box, you can type your questions in here during the webinar, and when we get to the Q&A section at the end, I'll read out the questions and share the answers for everybody, and I'll try and get through as many questions as possible in the time that we have left available. So let's get started on the impact of the EU General Protection Data Regulation and how that links through to the requirements for conducting data protection impact assessments. So Article 99 sets out the enforcement timeline for the GDPR, which we're all aware of. GDPR came into force 2 years ago on the 24th of May 2016 and is applicable since 25th of May this year. The regulation deals with the data rights of individuals, wherever they might be, irrespective, as the regulation says, of nationality or place of residence, and applies to entities based in the EU and to entities outside of the EU who are providing goods or services to residents of those in the European Union. The basic requirement is that those organisations that are within scope have to put in place a management system to enable it to clearly demonstrate that it is doing what it needs to do to protect personal data, and to have appropriate technical and organisational measures in place to ensure it is appropriately protecting data. The regulation is binding across all member states of the EU, so the Data Protection Commission, who's our supervisory authority here in Ireland, has powers of investigation, assessment and enforcement in accordance with the provisions of the GDPR since the 25th of May earlier this year. This means that you need to put your DPIA policy and procedures in place to ensure compliance as soon as possible if you haven't already done so. You can download a copy of the regulation from the EU's website, and you will see the link at the bottom of this slide, which brings you to the final text of the GDPR. It is important when thinking about who might have to do DPIAs to also think about the material and territorial scope of GDPR. In scope for GDPR is all personal data. Personal data is anything that can be used to identify a natural person, so a living person. For example, an email address, joesoap@gmail.com, identifies me and therefore is personal data, identifies Joe Soap. GDPR makes no distinction, however, between consumer and business data. So joesoap@itgovernance.eu is also personal data and therefore within the scope of the regulation. However, an email address such as info@itgovernance.eu would not be considered personal data and therefore would be outside the scope of GDPR. There are no rights under GDPR for the deceased, with the exception of a deceased person's estate, which may include the personal data of a living person, such as a beneficiary. Natural persons have rights to the protection of the personal data, to the protection of the systems that process their data, and the unrestricted movement of their personal data within the European Union. The GDPR covers personal data that is processed wholly or partly by automated means. So essentially any personal data on a computer or database. The GDPR also applies to any personal data that is part of a structured filing system. So any application forms that may be uploaded to a computer or stored in a structured paper filing system. So therefore GDPR applies to personal data on paper just as much as it applies to personal data in digital format. The GDPR applies to controllers and processors located in the EU, irrespective of where the processing activity itself takes place. So this means that a controller that outsources its processing to somewhere outside the EU, such as America or India, would not escape the remit of the GDPR. The regulation also applies to any controllers or processors who are based outside the EU but are providing services which are targeted at individuals within the EU. The regulation is enforced by quite significant fines. The fines are supposed to be effective, proportionate and dissuasive, but how effective, proportionate and dissuasive are applied remains to be seen, as it is to be decided on a case-by-case basis. But organisations certainly shouldn't assume that the higher level fines will not be administered just because it would be detrimental to the company. The new fines are a two-tier structure, which means that organisations can be fined up to either the lower level fine or the higher level fine. The lower level fine of €10 million or 2% of worldwide annual turnover, whichever is greater, can be imposed for certain breaches, such as failing to notify breaches to the supervisory authorities or to data subjects, for not observing the requirements of data protection by design by default, or even for failing to appoint a data protection officer, or DPO, where it is mandatory to do so. The higher tier fine of €20 million or 4% of total worldwide annual turnover will be imposed for breaches of the fundamental articles of GDPR, such as the principles of data protection, the lawfulness of processing, data subject access rights, cross-border transfers, etc. Administrative fines can be imposed in addition to or instead of the corrective powers of the supervisory authority. These include the ability for supervisory authorities to issue warnings or reprimands, or indeed order controllers or processors to comply with data subject access requests, as well as order an organisation to communicate a personal data breach directly to the data subject, or even order a company to cease processing. When determining what level of fine to impose, supervisory authorities will have to consider the nature, the gravity and the duration of the breach, and whether the organisation has been intentional or deliberate in infringing the regulation. Supervisory authorities will also have to factor in any action taken by the controller or the processor to mitigate the damage suffered by the data subjects, as well as the degree of responsibility of the controller or processor in the breach, taking into account technical and organisational measures. A data protection impact assessment is described in Article 35 of the GDPR, and the benefit is to help an organisation identify and at an early stage in creating a process or introducing a new technology or new product to address risks to the rights and freedoms of natural persons. So a DPIA is a process to identify and reduce privacy risks. It should be initiated and maintained throughout the development and implementation of a new project or system. So if you are planning a project, you should build into the project plan the need to complete a DPIA, which goes towards then demonstrating data protection by design. A DPIA is the overall process used to analyse how what you're planning to do with personal data is going to affect the rights and freedoms of the data subjects. Conducting DPIAs are a good way to demonstrate both that you are taking steps to consider privacy risks and how to mitigate them from the start of the project lifecycle. Moreover, since your DPIAs include an assessment of the lawful basis of your processing, they include the purpose of processing, etc., a DPIA can therefore help individuals understand how and why you are using their information and more easily see whether you are complying with your obligations under the regulation. The key requirement in the first data processing principle is that personal data must be processed lawfully, fairly, and in a transparent manner. The second principle states that the personal data must be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. The transparency benefit that you get out of completing a DPIA helps you to meet both of these principles. Organisations may wish to publish their DPIAs in relation to processing on their website in order to enhance trust with their clients and other data subjects, as it helps data subjects understand how you collect and process their information. This would be a very good way to demonstrate compliance with your GDPR obligations around transparency. However, for those of you that are concerned that your DPIAs might reveal information you don't wish to disclose or are not obliged to share with others, then you could publish your DPIA with those elements redacted. By applying the sixth data protection principle, which the DPIA drives you to do, you can ensure that the data is secure. And because a DPIA gives you an overview over what information you process and why, it also enables you to more easily review whether the information you collect is strictly necessary for your purposes in processing it. A DPIA therefore makes it easier for you to apply the principle of data minimization. Applying this principle has benefits for your organisation, such as a reduction in costs of processing. For example, the less information you process in your systems means the less data that you store and therefore lower cost. If you don't accurately assess the risks, it could cost you if something goes wrong, like for example, reputational damage, fines, court actions, etc. Consistent use of DPIAs can also foster a more robust culture of privacy in your organisation. If you build the DPIA into your project process, you will ensure that all relevant staff involved in designing projects think about privacy at an early stage of the project, how to identify vulnerabilities and how to mitigate them. When data protection officers or DPOs should be consulted on DPIAs, other personnel involved in the process should also receive relevant training regarding conducting and using DPIAs. Because a DPIA addresses each of the 6 data protection principles in relation to each processing activity, DPIAs are a useful tool for helping to ensure that your organisation properly complies with their GDPR obligations when processing personal data. Whilst a DPIA is not always a legal requirement, the Data Protection Commissioner may often ask an organisation whether they have carried out a DPIA. It will evidently be much harder for organisations that don't conduct DPIAs to evidence that they are upholding their obligations around privacy by design, since it is difficult to consider all relevant privacy risks from the start of a project lifecycle and how to mitigate them without first conducting an objective assessment. A DPIA is another way of demonstrating that an organisation is meeting its accountability requirement. And because DPIAs help you to review what data you collect and why, it means you are able to better review whether there is a less intrusive means of achieving the same purposes of processing. So conducting a DPIA can give assurance to the board and to individuals that you are complying with your data protection obligations, as well as giving assurance that you have followed best practices within your project. Now we will take a look at the legal requirements for conducting DPIAs. So DPIAs are a means to identify high risks to the privacy rights of individuals when processing their personal data, and they are an essential component of embedding privacy by design and default into your project life cycles. When the processing activity you are undertaking is potentially high risk, organisations are required to conduct DPIAs. That is not to say that the organisation cannot conduct DPIAs in any other circumstance, and in fact it would be considered best practice to do so. But that is certainly the only instance in which conducting a DPIA is obligatory. The legal requirements for DPIA are set out in Article 35 of the General Data Protection Regulation. The regulation instructs that DPIAs should focus on those types of processing operations which are likely to result in a high risk to the rights and freedoms of natural persons by virtue excuse me, of their nature, scope, context and purposes of the processing, and further instructs that this should include where the processing involves the use of any new technologies. The regulation does not define what high risk is, but high risk is something that comes from your organization's own risk assessment methodology that allows you to be able to determine what high risk is. The DPIA needs to include a systematic description of the processing activity and the necessity and the proportionality of the operations. DPIAs are required to be completed when personal data is to be processed for the purposes of automated decision making, including profiling, where there are legal effects for individuals. Relevant examples would include tracking people and performing automated credit checks. Similarly, if processing is on a large scale of special categories of data or personal data relating to criminal convictions, then a DPIA would need to be drawn up, which means, generally speaking, hospitals will need to conduct DPIAs as standard practices, insurance companies, etc. And finally, any systematic monitoring of publicly accessible areas on a large scale will also trigger the need for a DPIA, which obviously captures things like CCTV operations then within its scope. The DPO's advice should be sought during the DPIA process, particularly if there is a high risk to the rights and freedoms of natural persons. The Data Protection Commission has issued advice in relation to when DPIAs should be conducted, who should be involved, etc. You can view this advice on their GDPR and you.ie website. In addition, the Data Protection Commission is obliged under GDPR to publish a list of operations that require a DPIA. A draft list was issued by the Data Protection Commission in June 2018 for public consultation. The submissions received then by the Data Protection Commission from this consultation were used for the purposes of finalising the draft DPIA list for submission to the European Data Protection Board and for the purposes of any future guidance materials which the Data Protection Commission may produce. The final list itself has not yet been published. This is what the regulation stipulates you need to include in your DPIAs as a minimum. So what type of processing is taking place and the purpose of this processing. It must set out what the legitimate interests of the controller are, and remember that the data protection principles require that there must be a lawful basis for the processing of personal data. The necessity and the proportionality of the processing must be assessed. That is, whether your purposes could be achieved with less intrusive means or with less data, as well as an assessment of the associated risks to the rights and freedoms of data subjects. It is important to consider that what you are going to do to address the risks. So, for example, are you using codes of conduct? Or you maybe should look at what codes you could comply with. Any other safeguards, national or international standards that you could comply with in a way that will identifiably reduce the risk to the rights and freedoms of natural persons. In assessing the risks to the rights and freedoms of the data subjects, it is worth highlighting that it is the risks to the data subjects that need to be considered, not the risks for the controller or the processor. Where appropriate, the views of interested parties should also be considered. For example, some companies use focus groups or stakeholders to obtain their views before implementing large changes. And this moves us on to considering privacy risk as well as prior consultation with the Data Protection Commission. The regulation, again, doesn't tell us what high risk is. You have to determine this for your own organisation. We look at a few definitions of what risk is considered to be on this slide. However, ultimately, risk is a combination of the likelihood of something happening and the impact on the organisation if it happened. Now, each company has their own attitude to risk, which means that it is for each organisation to determine what constitutes high, medium and low levels of risk within your organisation. And it is this variation in risk attitude that produces different policy and different security standards, which as a result produce different security systems. And this is why there's a range of standards available for managing information and cybersecurity risks. So, for example, ISO 27001, ISO 31000, Cyber Essentials. When we talk about privacy risk, we are really talking about risk to the organisation and the individual. Of course, we're talking primarily about the risk to the individual and from their viewpoint. What happens if the individual if their data is corrupted, if someone is able to steal their data, if their data is not available for the purpose for which it was collected. All of these lead to impact on the individual with the potential for damage or distress. There is also risk to the organisation. The risk to the organisation comes with the loss of customers, loss of reputation, and of course from possible data subject actions against the organisation and the risk of regulatory action in the form of fines. So privacy risk should really be on the corporate risk register. There is a requirement under Article 5, Clause 2, that the organisation be able to demonstrate compliance with the data protection principles, and having privacy risk on your corporate risk register would go towards demonstrating this compliance or this accountability. So privacy risk emerges from data that is insufficient or out of date. You could imagine the life-threatening situations this could provoke in a medical context, for example. So for example, if a patient file is missing information concerning a patient's allergy to penicillin, and this is subsequently administered, the hospital would likely have to answer to malpractice suits as well as failure to uphold its obligations under the regulation. If you keep information for too long, the failure to observe the limitation of data, then the period of time that it is exposed to attack increases. This data could be stolen in a cyber breach or from an inside threat, such as a disgruntled employee. Information that is disclosed to people without prior notification or consent of the individual concerned could cause serious damage, such as releasing somebody's banking and card information to another unknown individual. And obviously information that is insecurely transferred or stored could provoke a series of distressing situations for the individuals to whom the data belongs, as insecure transmission and storage leaves the information open to all manner of threats on its confidentiality, integrity and availability. You might consider carrying out a DPIA in any number of instances throughout the organisation. For example, combining databases so as to consolidate information held by separate parts of an organisation. This would require DPIA for two reasons. First, the more information you have together, the greater the harm and impact a data breach could cause. And second, consolidating the database would mean staff from different parts of the organisation would be able to view and access information that they had not previously access to when it was in a separate database. As the number of staff accessing data increases, so does the risk to individuals identified by that data. If you're monitoring members of the public and monitoring is deemed a more intrusive form of processing, then you should complete a DPIA. In the case of a new system being implemented to process personal data, the regulation specifically stipulates that DPIAs are mandatory where organisations are using new systems to effect the processing. If you are going to share the data with a third party, likewise a DPIA should be completed. So it should be standard practice that when you want to process information for a different or more intrusive purpose than for which you initially collected it, that you draw up a DPIA to identify any risks associated with this new purpose. Some actions that could be taken to reduce the impact to an acceptable level of risk to the individual could include reducing the amount of data collected. So assess the amount of data being collected against the purpose for which it is collected and exclude any unnecessary or excessive data. By implementing a data retention policy, therefore not retaining data for longer than is necessary for the purpose for which it was collected. by securely destroying data, implementing an access control policy and procedure, implementing and delivering training and awareness programs throughout the organisation to all employees, pseudonymise data where possible, or when liaising with third parties, use data sharing agreements or a GDPR compliant adequacy arrangement such as binding corporate rules or model clause contracts, and have external supplier risk assessments in place. Have an acceptable use policy and a subject access request policy. Have them in place where all employees are aware of and adhere to them. Once you have conducted a DPIA for your processing activity, if it identifies your processing as posing a high risk to the rights and freedoms of data subjects, then the regulation under Article 36 requires that you seek prior consultation with your relevant supervisory authority, so that is the Data Protection Commission, before proceeding with the processing. The Data Protection Commission must respond by providing advice in writing to the controller, and for the purposes of prior consultation, the supervisory authority can request for any information in relation to the DPIA, including further information on the purposes and means of the processing identified as high risk. They can request information regarding what safeguards you have in place to mitigate the risks, the contact details of your data protection officer, etc. So a DPIA is a key tool of GDPR compliance and is also therefore a key part of an organisation's risk management framework. Article 32 talks about how an organisation can use its adherence to an approved code of conduct or certification mechanism. So, for example, ISO 27001 is an information security standard against which you can be certified. You can use these in ways that demonstrate that you have put in place appropriate controls to meet your requirements, to have relevant organisational and technical measures in place to protect the rights and freedoms of data subjects. Information security or cybersecurity management systems such as ISO 27001, business continuity systems like International Standard 22301, and a personal information management system such as British Standard 10012 are standards that you can use to demonstrate that you have taken appropriate steps to meet your compliance obligations. It is important to note that certifications do not remove or reduce accountability for data protection, but they can be used as best practice guidance and will demonstrate compliance in approaching the Article 32 requirement. Article 32 says the controller and processor have to really cooperate to make sure appropriate measures are in place to protect the rights and freedoms of natural persons, and these measures should be appropriate to the risk. It defines very clearly that the risk is anything that might undermine the confidentiality, integrity, or availability of the data, whether in flight or at rest, so access to personal data transmitted, stored, or otherwise processed. Conducting risk assessments and DPIAs will be for many organisations a starting point in their GDPR compliance plans, because this allows you to objectively assess the varying likelihood and severity of the possible risks, which will better inform your compliance plans so you know where your vulnerabilities lie and what type and level of controls you have to implement. Data protection officers play a key role in managing the relationship between corporate risk management, broader cyber security risk management, and managing risks to personal data, which means that your DPO needs to have at least an understanding of risk management terminology and frameworks. So how do we go about conducting a DPIA? We recommend 7 steps, which I will talk you through now. Step 1, identify the need for a data protection impact assessment. So apply some screening questions to the processing to determine if a DPIA is required. These screening questions would interrogate the volume of data, the variety of data, and type of data being processed, whether it is strictly necessary for purposes, whether it's possible to deliver the same service without collecting so much data, etc. Examples of screening questions you could use are, does the project involve you using new technology which might be perceived as being privacy intrusive? Will the project result in you making decisions or taking action against individuals in ways which can have a significant impact on them? Does the processing involve special categories of data, etc.? Your screening process needs to be embedded into your organization's project management process so that you are able to identify the potential impact on privacy of each project processing personal data. This will help you to consider how project management activity can address privacy issues from an early stage in your project lifecycle, as well as discussing these issues with the stakeholders, meaning you have accountability from the outset. The overall output of this exercise is that you should be able to adapt the development of your project to address the privacy concerns raised by the screening questions. Step 2 then, describing the information flow. So here we would recommend conducting a data flow audit, so drawing a data map of the processing, so as to ensure you're considering all aspects of the processing in your risk assessment. A thorough assessment of privacy risks is only possible if your organization fully understands how information is being used in a project. You should be able to describe how information is collected, stored, used, and deleted. And this is obviously where your data map comes in. An incomplete understanding of how information is used can be a significant privacy risk. For example, data might be used for unfair purposes or disclosed inappropriately or further processed. It is perfectly fine, by the way, to integrate the DPIA with any similar exercises which may have already been done for the relevant project. So, for example, your organization may already conduct information audits, have developed architectural diagrams, data flow charts, or they may make use of information asset registers. Moving on to step 3 then, identifying privacy and related risks. And this is where you use the data map to inform your DPIA so as to identify the privacy risks to the individuals concerned. Different organizations have different risk criteria, and what one organization treats as tolerable risk, another organization might classify as a significant risk, which requires treatment. Risk appetite is the organization's approach to balancing risk and reward, taking account of its capacity to absorb loss. Step 4 then, identifying and evaluating privacy solutions. So having identified your privacy risks, you then need to assess the costs and benefits of treating or mitigating those risks by looking at the impact on privacy and the effect on the project outcomes. You should record those privacy risks which you've decided to accept as necessary for the project to continue. You have options for how you can respond to each of your privacy risks as identified by your assessment. You could terminate the risks. So, for example, that would be anonymize or delete the data to remove the risk from your organization or remove the risk from to the data subject. You could treat the risk, so by encrypting or pseudonymizing information. Privacy risk treatment may also involve implementing safeguards such as access controls or segregation of data. You could transfer the risk, so take on an insurance policy against the risk or transfer the processing to a third party. And you could finally tolerate the risk, so where further action to reduce the risk is not justified, for example, where the cost of treating the risk outweighs the potential impact, or where the likelihood of it occurring is very low, then you may choose simply to accept the risk and not take further action. Signing off and recording the DPIA outcomes then is part of step 5. A DPIA does not necessarily require a formal signing off process, but this will depend on the nature of the project. If an organization is working on a large-scale project with a higher level of risk, it would be good practice to ensure that the DPIA has been approved at a senior level, preferably by the relevant information asset or risk owner. For smaller projects, it can be appropriate for the project leader to accept the privacy risks. A signing off can also help to ensure that the necessary actions are followed up. Keeping a record of the process can also be used to assure the public the supervisory authorities, and other stakeholders that the project has been thoroughly assessed and the associated privacy risks properly considered and treated. Integrating the DPIA outcomes back into the project plan then is step 6. The results of the DPIA should be fed back into the wider project management process. This will usually need to take place while the project is still being developed. So, for example, the DPIA may need to be referred to or expanded in the future. The DPIA process should be developed to integrate with your organization's project management processes. And finally, step 7, monitor and evaluate. Feed lessons learned back into the process. So organizations should take care to ensure that the steps taken as a result of the DPIA have been properly implemented and are having the desired effect. This is why continuously referring back to the assessment is a good way to ensure that the planned actions are being taken and privacy risks properly managed. So there you have 7 practical steps to conduct a DPIA. Of course, in IT governance, we can help you or help you to help yourself. We can provide things like pocket guides, implementation manuals, templates for all the necessary documents. We have a gap analysis tool that enables you, with a bit of knowledge of what you're meant to be doing, to work out where your gaps are and therefore what you need to do. We have a data flow mapping tool which will help you gain full visibility over the flow of personal data through your organization and meet the requirement to maintain a record of processing activities, which is under Article 30 of GDPR. We have a range of training courses that can be delivered online in-house or in one of our public venues in Dublin, Cork, Limerick and Galway. We have e-learning courses that you can provide to your staff to build awareness company-wide. We also have a range of consultancy services ranging from a gap analysis, conducting data flow assessments, implementing information security management systems, cyber health checks, conducting DPIAs, carrying out data protection audits, and we also offer a data protection officer as a service because there's no requirement on you to employ a data protection officer. You can outsource this role and you can appoint someone on a part-time basis for a number of hours, a week or a month, whatever is appropriate for the needs of the organisation. We have a couple of free webinars planned over the coming weeks, focusing on conducting a data flow audit and appointing a data protection officer. Please click on the link provided on this slide to register your interest. You can contact us via any of the mediums shown here for any questions or queries that you may have. And this brings us to the end of the prepared portion of today's webinar. So now we will look at some of the questions received so far. Just a reminder, if you do have any questions, please use the questions function in the GoToWebinar panel on your screen. You'll see a box marked questions. If you open that box, you can type your questions in here. I will read the questions out and then answer them, and I will aim to get through as many as possible. Okay. Firstly, I suppose I should say that these slides will be made available to everybody who registered for this webinar, and they will be made available a few days after the webinar itself. And also a recording will be made available in due course, a recording of the webinar itself. Okay, so first question here, you mentioned that GDPR applies to data associated with a business email address, such as joesoap@companyx.co.uk. Does this mean that I have to consider getting consent from individuals for releasing information under a freedom of information request in the case of a public body? I think there's a couple of different items that we need to consider within that. First of all, if there is a name in the email address, even if it is a business email address, it is considered personal data. With regards to getting consent for releasing information under a freedom of information request in the case of a public body, I suppose you need to go back and look under the data subject rights in GDPR, and there is the subject access request details under the GDPR that give you the reasons when you can release information, when you cannot release information, and certainly in the case of subject access rights, you should really only be issuing the personal data relevant to the person that has requested that information. Yeah, okay. Does the scope of GDPR cover overseas subsidiaries of companies? Yes, it does, if those subsidiaries are processing the personal data of citizens of the EU. So, for example, you could have a company in Spain and Ireland that have maybe a head office in the States. If you are transmitting personal data to the people in the States, if they're seeing the data of the European residents, then GDPR does apply. You could have a developer, an IT developer working on your IT systems in India, who could be logging into PCs in Europe to work on the development side of the system, and if they are viewing personal data of EU residents, well, then they are also considered within scope of GDPR. And certainly in both those cases, both the US and the India, they are outside of the EEA, and they are not considered third countries for having adequacy requirements in place. So certainly you'd need to have a more protective data processing agreement in place, such as a model clause contract. Is there a recommended template for the DPIA? There isn't a specific recommended template out there yet. Certainly we, IT governance, do have templates, and we have that. You can go in on our website and view the toolkit in relation to DPIAs. The Data Protection Commission has issued their consultation guidance back in June. Again, it doesn't give a template, but it does list the areas that they would expect to see in a DPIA. Okay, what is the situation around companies being required to hold customer data under laws other than GDPR? So under Article 6 of GDPR, it sets out the 6 lawful bases that can be used to ensure that the processing of data, personal data, is lawful. You must ensure that at least one of the bases can be assigned to each processing activity. One of these is that processing is necessary for compliance with a legal obligation. So if there is a legal obligation on your organisation to retain certain information, then that is your lawful basis for doing so. GDPR is only applicable to personal data, so what about company or IP data? A DPIA is specifically mandated for assessing the impact to the rights and freedoms of individuals, but the methodology could equally be applied to corporate and other confidential or non-personal information, because the DPIA essentially draws on well-established risk management principles and processes. I work for a company with our own data center, which our clients use. Who should complete the DPIA? So the GDPR is very clear in that it says the controller should complete the DPIA. The controller is the entity that determines the means and the purposes of the processing. Any third-party processors that the controller contracts with for any part of the processing of that data should, where necessary, contribute to the DPIA process. So therefore, you as a data center should have a very clear contract which sets out your obligations in terms of the processing that you do. So I suppose in summary, the controller has to complete the DPIA, but you should contribute to it. Okay. We are processing large volumes of just name and email data. Do we need to complete a DPIA? You probably should complete a DPIA to assess if you're capturing any other types of personal data, possibly online identifiers. And I would suggest if you're processing large volumes of personal data, then you should complete a DPIA. What is deemed high risk to the rights and freedoms of data subjects? Okay, very good question. GDPR does not tell you what high risk is. You have to work this out via your risk assessment methodology, which GDPR tells us what we must have. Your risk assessment methodology must have some form of risk scale, which looks at what high risk might be. And one way of determining what high risk is to put yourself in the shoes of the data subject and ask, what would be a real problem for me? What would cause me significant distress? And I would suggest that anything involving identity fraud or access to special categories of personal data, personal records or banking information or data relating to children should be considered as high risk. And yeah, so high risk is really going to be about volumes of personal data and volumes of data subjects, as well as the type of personal data. Has the Data Protection Commission issued the final list for the processing activities that believe warrant a DPIA? No, not yet. The draft list was issued via their website in June 2018, and you can actually go in and view that. It has quite a lot of information on it. However, the view was that they were going to take in consultation, which closed in July, I believe, and then send a proposed final list to the European Data Protection Board for approval. But this final list has not actually been issued yet. How do you calculate the time needed to complete a DPIA? It depends on the number of people involved in the process, how well documented the process is. So if you have a well-documented process, you may already have data maps in place. You then already know what happens with the personal data within the process. So you'd know what type the data is, and the people involved in the processing probably know what they were doing. So you could probably complete a useful DPIA then inside a business day. If it's a very substantial and complicated process, though, a DPIA could take you between 3 and 5 days. Is there a definition of large scale of data processing in the GDPR? No, however, there is guidance within the public consultation paper that the DPC, the Data Protection Commission, issued that advises that while the regulation doesn't define large scale, that we should take into account the duration or permanence of the data processing activity, the proportion or the number of data subjects, the volume of data, and the different data items being processed, and the geographical extent of the processing activity. This consultation document does give examples of large-scale processing, and the examples it gives would be like a hospital processing patient data, tracking individuals using a public transport system, a supermarket chain tracking real-time location of its customers, a bank or an insurance company processing customer data, a search engine processing data for behavioural advertising, or a telephone or internet service provider processing user data. It does note on the guidance that individual professionals processing patient or client data are not processing on a large scale. Is a DPIA required for processes and systems that were in place before the 25th of May 2018? So the GDPR requires compliance from the 25th of May. So if you have a process that existed before the 25th of May, but you were still conducting this process activity, and that the process activity is considered high risk to the rights and freedoms of individuals, then you should conduct a DPIA. You mentioned earlier about publishing DPIAs. Is there a requirement to publish my DPIA? No, there is no requirement to publish your DPIA. Some companies do publish parts of their DPIAs via their website, but this is a choice for each organisation, and it's certainly not obligatory under GDPR. I'm just going to see if I have a few more questions. Okay, and I think that is actually all the questions that we have here. Okay, so thank you very much. I hope you found the webinar useful. You can access, of course, all our range of products and services which can help you get your GDPR compliance in place and your DPIAs up and running via the links and contact details on the slide deck, all of which are also on our website, itgovernance.eu. We have a very substantial team of GDPR specialists as well as information security management specialists. And I would like to thank you all for being on this webinar. I wish you good luck with embedding your DPIAs in your organisation. So thank you and have a good afternoon.